Allegations of bribery are relatively common in the commercial court, allegations of torture less so, but in Shagang and HNA, the two coincided. HNA sought to defend Shagang's claim under a guarantee on the basis that the underlying charter party had been procured by bribery. HNA relied on confessions to the alleged bribe given to a police force in China by the individuals who had allegedly paid and received it. Shagang in turn contended that those confessions had been obtained by torture on the part of the police officers and were therefore inadmissible in evidence pursuant to the exclusionary rule to that effect in A and Secretary of State No. 2. Alternatively, Shagang argued that no weight should be afforded to the confessions in any event. At first instance, Mr. Justice Knowles found in favour of Shagang, finding that the alleged bribery had not been proved on the balance of probabilities. He also stated, separately, that he could not rule out the possibility of torture. The Court of Appeal allowed an appeal by HNA and remitted the matter back to the Commercial Court for redetermination. One of the grounds on which they did so was that the judge had erred in law in failing to exclude irrelevant matters from consideration in light of his finding that torture could not be ruled out as a reason for the confessions. The Court of Appeal relied in this respect on the so-called binary principle, as expressed by Lord Hoffman in the House of Lords decision in B, to the effect that if a legal rule requires a fact to be proved, a fact in issue, a judge or jury must decide whether or not it happened. There is no room for a finding that it might have happened. The law operates a binary system in which the only values are 0 and 1. HNA had argued, and the Court of Appeal accepted, that applying this binary principle, the fact that the judge had not found in the balance of probabilities that the confessions had been procured by torture was in law a finding that there was no torture, with the consequence that in estimating the weight to be attached to the confession evidence, the judge was bound entirely to disregard the possibility that the admissions had been obtained by torture. The Supreme Court has disagreed, not only in light of the principles expounded in A and Secretary of State No. 2, but also in light of the general principles of the law of evidence, as enshrined in the case of hearsay evidence in Section 4 of the Civil Evidence Act. The Supreme Court has confirmed what one might have thought was obvious, namely that in assessing what weight, if any, to give to evidence, a court is entitled to have regard to any matters from which any inference can reasonably be drawn as to the reliability or otherwise of the evidence. The Supreme Court has stated that nothing in Re B dictates any contrary conclusion. Whilst it is correct that if a legal rule requires a fact to be proved, then the law operates a binary system, not all legal rules do require relevant facts to be proved in a binary way. In particular, the assessment of weight does not admit of such a binary approach. That assessment is an evaluative, multifactorial exercise, and the circumstances to which a court may have regard are not limited to facts which have been proved to the civil standard of proof. Nor does it follow from the fail to prove a fact for the purposes of one particular legal rule, for example, in relation to the admissibility of evidence, that that fact must be treated as not having happened for the purpose of other legal rules as well, for example, in relation to the weight to be afforded to the evidence. Rather, one needs to identify what the facts in issue are for the purposes of the particular legal rule in question. In Shagang and HNA, torture was not per se a fact in issue in the sense of something that needed to be proved for the purposes of Shagang's claim under the guarantee. The possibility that it had taken place, however, was a factor that the judge was entitled to take into account when weighing up the reliability of the confession evidence for the purpose of deciding the facts in issue whether there had been a bribe. The Supreme Court decision is also interesting for its rejection of the Court of Appeal's conclusion that the judge had failed more generally to address the question of what weight should be given to the confession evidence, or say why he had rejected it as unreliable. The Supreme Court was critical of the first instance judgment in several respects, and agreed that it would have been more satisfactory for the judge to have set out his reasoning in greater detail. Nonetheless, it was not a case where the judge had failed to have regard to material evidence. Rather, the real complaint was as to the degree of depth in which he did so, and that he did not do so in a sufficiently systematic way. Such a shortcoming, said the Supreme Court, whilst regrettable, did not involve an error of law or otherwise justify intervention by an appellate court. The judgment therefore provides a salutary reminder that a judgment may have its shortcomings, but nonetheless still not be appealable. Thank you for listening.